rare and balanced view on politics in today's world. Based on facts, born of rationality, common sense, and logic, providing context on today's events. This is American Perspective with Rick Thomas.
Hello, everyone, and welcome to American Perspective. I am your host, Rick. Well, SCOTUS decided to kick out the rest of their cases today. They took one and actually referred it back for re-argument, meaning that they'll pick it back up when they come back for their next term, which I believe starts in August for the what do you call it? For their next term, whatever it is. I think they call it the October term. But anyway, they're going to be picking that one back up. That was the Louisiana case. I don't know all of the details, but I know that it's rare for that to occur. So obviously something they are thinking about something having to be relitigated, I guess, is the best way to term it, within that case. But the other cases that they have, they spit out all of their opinions, including the ones the three that I've been waiting on, in particular, the birthright citizenship one with the that is not arguing the birthright citizenship, but does go into the nationwide injunctions. I've got that tonight for you. Also, too, we have a beatdown of a DEI advocate who was testifying and basically got asked a question that they couldn't quite answer. So, they couldn't answer within their own philosophy or their own ideology, I should say. So there's that. And also, too, there's a top economist who mentions that, maybe Trump and the tariff thing, maybe he does know what he's doing. I got that, too. All right. So let's go ahead and get things kicked off. Tonight is, of course, the venerable, the wonderful, the fantastic Mrs. Whiskey's version of the Pledge of Allegiance. So if you are of mine, please stand, remove your hat if you're wearing one like me, and follow along with Mrs. Whiskey as she recites the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
And, of course, I thank that beautiful woman who decided to bless my entire life with her presence. And, okay, if you would like to have your rendition of the pledge played here on the program, all you need to do is record yourself reciting the pledge in your style. And, of course, take that audio file, video file, whatever kind of file, and attach it to an email. Send it off to me. Send it to fans, F-A-N-S, at AmericanPerspective.online. That's fans, F-A-N-S, at AmericanPerspective.online. And I, of course, will get you into the rotation. Tonight's headline sponsor is theflagshirt.com. I'm wearing one of their wonderful shirts right here today. Great colors, wonderful. They go through the wash and they keep their colors quite well. And they have guaranteed delivery still for Independence Day. Independence Day, of course, being 1 week from today. So you should, yes, Bonnie, she does put up with me. So you should get your order in as soon as possible so they can guarantee that delivery before Independence Day. Go and check out their men's, women's, kids, made in the USA, all kinds of stuff. They even have 4th of July outfits They have 4th of July outfits, like they pick it and they put it all together for you, and it's just fantastic. Plus accessories, all in the red, white, and blue. So go to theflagshirt.com and check out all of those styles. Check out everything that you can. And if you purchase $75 or more of their product, they will give you free shipping. And once again, that is guaranteed for the Independence Day holiday next Friday, 1 week from today. Can't believe we're already here to our No Kings Day, our actual No Kings Day. But anyway, as I said, and I digress, not very many people want to purchase $75 or more of their product. Doesn't mean they don't like it. It's just maybe they only want one shirt or maybe a few accessories, and they can't get to that $75 mark. Well, that's fine, because I have a special deal for you. If you head over to flagshirt.americanperspective.online, that's flagshirt.americanperspective.online, you will be presented with a coupon code that you can copy and paste into the promo box at checkout at theflagshirt.com, and that will give you $5 off your order. Go to flagshirt.americanperspective.online, be presented with that coupon code, copy and paste that into the promo box at checkout at theflagshirt.com, and they will give you $5 off your order on American Perspective. Go to flagshirt.americanperspective.online, get that coupon code, paste it in the promo box at checkout at theflagshirt.com, get $5 off your order. Go to theflagshirt.com and get yourself patriotized. All right. Well, let's take a look first. So there was a resolution. Now, okay, so here's kind of the thing that sometimes Congress, in particular the House, and even the Senate, they sometimes do this too, where they'll put forth a resolution that is doesn't have anything to do with an actual law or whatever, but they'll just put forth a resolution like saying something like, well, this resolution is to demonstrate our support for Israel or something along those lines. And they'll vote on it. It's a procedural vote. It doesn't really mean anything. It doesn't change anything. It doesn't give anybody anything. It doesn't change any money. It doesn't change hands, things like that. But it demonstrates things, and it demonstrates where the politics of the House in particular, in this particular case, are in relation to some event. Okay. It's all, ceremonial and everything else, but it demonstrates how, in some cases, like this one, how horrible Democrats actually are. So here, nearly 200 House Democrats rejected this resolution condemning the violent anti-ICE riots in L.A. So, yeah. Seriously, why would you not? I mean, that's kind of like saying, a mass murderer, needs to be held to justice. I mean, seriously? This is kind of a no-brainer. Of course you should reject or you should agree with the resolution condemning violent anti-ICE riots. They're violent. I mean, how stupid can these people be? Seriously, this is just so dumb. It's just so dumb. It's no different than them not standing up for that young man who had cancer and was a guest at the not quite the State of the Union speech that Trump gave when he first came into office in the chamber. I mean, All this does is it just shows you how petty and stupid and moronic they actually are, which is part of the reason why I call them morons. So anyway, they rejected this resolution, 200 of them, nearly 200 of them. The resolution was put up by Young Kim, who was a Republican from California, and the rest of the Golden State's Republican congressional delegation. 215 members of the House of Representatives, which included House Democrats, 7 House Democrats, voted in favor of the resolution. Kim stated when introducing it, peaceful protests are a constitutional right, but vandalism, looting, violence, and other crimes are not. Protecting public safety shouldn't be controversial, which is why I'm leading the California Republican delegation in a resolution to support law and order as we continue to see unrest. She added, I hope Governor Newsom can come together with President Trump to stop the riots, lower the temperature, and keep our communities safe. Seems pretty simple to me. I mean, you should be against violence. Kim also continued and said, let's be clear. The riots escalated before the National Guard was sent in and were enabled by California's soft-on-crime policies, peddled for years by Governor Newsom, Sacramento, and local prosecutors, that have allowed for lawlessness and endangered public safety of hard-working Californians. So it was introduced on June 17th, and it acknowledges that peaceful protests should be welcomed in the United States, but also calls out the criminal elements that unfolded in the area earlier this month. The resolution states these protests quickly escalated into violent riots across Los Angeles, where acts of arson, widespread looting, property destruction, and vandalism were committed, blocking streets and highways, lighting streets on fire, throwing rocks at law enforcement vehicles, and assaulting federal and local peace officers. I mean, that sounds to me like something that everybody should get behind. Why would you sit here and condemn or not support a resolution that calls that out? Well, that's because you're petty and stupid, and you want to, demonstrate that you're against law and order, which is, of course, what the Democrats have been for as many years as I can remember here recently. They've been against all this. So, yeah. Anyway, once again, Democrats show their true colors. They want to be behind criminals and illegals and all these other things that, and don't support the American way. All right. Well, you'll remember SCOTUS, and I'll get into the SCOTUS orders here in just a minute. But you'll remember SCOTUS not too long ago said that, the Trump administration can take and eliminate protected status. In particular, he was doing it against Venezuela at first. Well, now the Trump admin has ended temporary protected status for the Haitian migrants that are currently in the U.S. So this, of course, opens the door for increased deportations in terms of, in this particular case, roughly against the roughly 520,000 Haitians currently residing in the U.S. The Trump administration's Department of Homeland Security is ending that TPS for it, and it will expire on August 3rd of 2025. The termination will then be effective on Tuesday, September 2nd of 2025. And so what they're going to do is they're basically going to expire it and give them roughly 30 days to get their asses out. DHS spokesperson said this decision restores integrity on our immigration system and ensures that temporary protected status is actually only temporary. The environmental situation in Haiti has improved enough that it is safe for Haitian citizens to return home. We encourage these individuals to take advantage of the department's resources in returning to Haiti, which can be arranged through the CBP Home app. Haitian nationals may pursue lawful status through other immigration benefit requests if they are eligible. Nome, of course, made the decision to revoke TPS status after reviewing a U.S. Citizenship and Immigration Services report, which showed that Haiti no longer meets the statutory requirements that grant foreign residents the ability to obtain temporary protected status. And sources at the DHS tell Fox News that they are encouraging Haitians in the U.S. under the TPS to use the CBP Home app to secure a safe departure with a complimentary plane ticket and the $1,000 exit bonus. Yeah. Now remember, that was the change from the CBP One app to the CBP Home app shortly after President Trump took over. And yeah, so that's awesome. They're working on getting rid of the temporary protected status of these people. So, yeah. So there we go. Let's see. Yeah, Joe Biden originally granted the TPS status to the Venezuelans in 2021, and again before he left office in 2025, which of course Trump has taken out. And yeah, so there you go. Anyway, all right, so let's get into these SCOTUS. Things. Obviously, the number one is Trump versus Casa Inc. And, again, just to reiterate, this was not a case or the ask by the government was not a case, was not being asked, SCOTUS was not being asked to discuss or even entertain the merits of the idea of birthright citizenship. The ask by the federal government in the oral arguments on all of this was to remove the fact that the judges at district court levels had been issuing nationwide injunctions against people who have been bringing the cases. Now, one of the things that a lot of people misunderstand about injunctions is that injunctions are designed to have the courts intervene on behalf of either the plaintiff or the defendant in order to eliminate or restrict the amount of harm that could come to that particular individual in the case during the time that the case is being litigated. And so one of the things that they basically have done, and this, by the way, this goes way back, all the way past before, America was even America. It was designed to ensure that the litigants of the case could not be harmed while the case was being tried. And the idea of universal injunctions doesn't actually present itself historically before 1963, which was in the FDR kind of era. And so I think it's FDR. But anyway, 1963-ish is when they started bringing them back. Because even during the New Deal and everything else, even with the New Deal, they weren't like blanket injunctions that were put in place. And so the question has been, because universal injunctions, meaning nationwide injunctions, have been sort of a, historically speaking, sort of a modern historical creation, the question that was put before the court was basically, hey, how can a district judge who, yes, has control over said district, whatever district they are, But how can this district judge go and just put a blanket order and say, no, everything must stop? Well, that is ending. And the reason why it's ending is because of the fact that the court is granting the government a partial stay for the injunctions. Now, the partial stay is basically saying, yeah, you can put an injunction and have it enacted upon the individuals who are bringing the case, but you can't stretch it beyond that. And that's what they're saying. Which, again, I mean, I made this argument before. Universal injunctions, the ability for the district court, the federal district courts, which, by the way, were created by Congress. They are not constitutionally created. They are created by Congress after the fact. But what ended up happening here is that the individuals who are there, who are bringing the cases in particular, and they wrapped three, by the way, they wrapped three of them up into one case for all of this. But the individual injunctions for those individuals will still stay in place. They will still not be, deported. Their children will still be considered, in this particular case, will still be considered citizens when they're born or whatever. But it won't extend beyond those folks unless something else happens, like they end up getting into some sort of a class action lawsuit or something along those lines. Now, all of that being said, my understanding is the discussion or the case, the SCOTUS case in terms of determining birthright citizenship is likely to present itself in the next session, meaning that it's likely to show back up at the Supreme Court in the August to November session. And at that point, they'll be deciding on what birthright citizenship actually means. And I'll explain a little bit more on that here in just a minute. But the key, of course, is the fact that right here in blue above my head, the court has held that universal injunctions likely exceed the equitable authority that Congress has given to the federal courts. Now, here's the thing. This is soft language. This literally is soft language. Now, this was put together by Amy Coney Barrett. And she does do a fantastic job of slapping down Jackson, which is the reason as to why you've started to see all the leftists go, oh, I stand with, Justice Jackson. I stand with Justice Jackson. Anyway, we'll get into that in just a minute. But the key here is that by them saying likely, this isn't definitive. I really dislike it when courts make these soft language comments. They need to just basically say universal injunctions exceed the equitable authority that Congress has given to federal courts. That's what the statement should say, because they do. And so anyway, it continues on that and says, the court grants the government applications for a partial stay of the injunctions entered below, but only to the extent that the injunctions are broader than necessary to provide complete relief to each plaintiff withstanding to sue. Now, Amy Coney Barrett goes through this entire thing, and she talks and she dismisses each point. They, of course, if you've never read one of these opinions, this is kind of the way it goes. They essentially say, here's sort of the background of the case in a summary. Here's our answer to it. And then they go through this entire explanation in terms of how they arrived at the decisions that they did. And it goes through and it will point at different cases in the past and court precedent, or maybe it'll point out, historical values and things like that, which Amy Coney Barrett does in this opinion. She does point out that, again, like I just did a few minutes ago, that these universal injunctions, while the earliest that they can find is in 1963, they're relatively new, a modern sort of creation, and all of these things are, without any precedent before 1963. But one of the things that she does do, which is fantastic and fascinating, by the way, is that in her writing of the opinion and how she breaks it down, she goes down into, obviously they had, conversations about this and discussed this back and forth and everything else in terms of their internal conversations about it. But she smacks the crap out of Justice Jackson. And she doesn't do it with, the sort of, let's say, the sort of deference or reference to respect, saying things like, respectfully, we disagree. Respectfully, blah, blah, blah. And so in her point, she actually seriously smacks Jackson's position. You see right here, this is on page 23 of the dissent. It goes, rhetoric aside, Justice Jackson's position is difficult to pin down. She might be arguing that universal injunctions are appropriate and even required whenever the defendant is part of the executive branch. And then she goes, if so, her position goes far beyond the mainstream defense of universal injunctions. And then she continues and says, at best, or as best we can tell, though, we, meaning the concurring, the six that agreed with this. As best we can tell, though, her argument is more extreme still because its logic does not depend on the entry of a universal injunction. Justice Jackson appears to believe that the reasoning behind any court order demands universal adherence, at least where the executive is concerned. In her law-declaring vision of judicial function, a district court's opinion is not just persuasive, but has the legal force of a judgment. Yeah. Once a single district court deems executive conduct unlawful, it has stated what the law requires, and the executive must conform to that view, ceasing its enforcement of the law against anyone, anywhere. Now, here's the part that really, really kicks her in the pants. We will not dwell on Justice Jackson's argument, which is at odds with more than 2 centuries worth of precedent, not to mention the Constitution itself. We observe only this. Justice Jackson decrees an imperial executive while embracing an imperial judiciary. Yeah. And it's this phrasing that this whole section that the left is just freaking freaked out about. They are just going nuts. Because they also say, or she also, this Amy Coney Barrett's phraseology, she says, no one disputes that the executive has a duty to follow the law, but the judiciary does not have unbridled authority to enforce this obligation. In fact, sometimes the law prohibits the judiciary from doing so. She suggests that for the fact that the law prohibits the judiciary from actually getting involved, Marbury versus Madison. It's concluded that James Madison had violated the law, but holding that the court lacked jurisdiction to issue the writ of mandamus, ordering him to follow it. So, Yeah. This is part of the deal. Now, keep in mind, I mean, there was Andrew Jackson basically told the Supreme Court to F off at one point, and that was there as well, so on and so forth. You guys need to understand, there's only one court, and I told you this, there is only one court in this land that can actually stop or put an injunction upon or modify the anything that comes out of the the legislative or executive branches. And that happens to be the Supreme Court. But the Supreme Court does not have the enforcement power. It was never granted enforcement powers. Because the three branches of government are supposed to be partners in this. And so technically, if you go and decide, like Andrew Jackson did at one point, to just ignore SCOTUS, who's going to stop them? Now, normally that would be the people of the United States, because the people of the United States are the ones that give the power to the government, period. There is no other choice here. But this is the thing, is that I think it's hilarious. From my perspective, it's totally hilarious, because all of these leftists have been saying, oh, yeah, the judges, the judicial system has the opportunity and can do this. Not just unbridled law. The district courts, based on this opinion, and rightfully so, the district courts do not have the ability to issue universal injunctions. Now, keep in mind, that could change should Congress decide to write that in as a power, and then it becomes a question of whether or not Congress actually has the authority to pass along to the judiciary branch, the lower court system, the ability to issue nationwide injunctions. Which I think it brings up a great constitutional conversation about the fact that the only court that can do that is the SCOTUS. That being the case, she also continues down here and talks about the boundaries of the Judiciary Act of 1789, which, by the way, the Judiciary Act of 1789 is what created all the courts, the lower courts. And Amy Coney Barrett says, Justice Jackson skips over that part. She goes, because analyzing the governing statute involves boring legalese. She seeks to answer a far more basic question of enormous practical significance. May a federal court in the United States of America order the executive to follow the law? So, in other words, it is unnecessary to consider whether Congress has constrained the judiciary. What matters is how the judiciary may constrain the executive. Justice Jackson would do well to heed her own admonition. Everyone from the president on down is bound by the law. That goes for judges, too. Oh, I bet this one was just heated in the back rooms. I'm fairly certain this one was. Because obviously the three justices who are actually activists, not constitutionalist jurors or jurists, I bet you those guys were all like, oh, no, the judiciary. And, to some extent, maybe even Chief Justice Roberts might have kind of said something about that. Well, the judiciary, because he likes to have the judiciary put their mark on stuff, but not in a broad sense. He only likes it in a very narrow sense. Anyway, yeah, for once, I will have to admit, Amy Coney Barrett would definitely have fun, or had fun, with writing this opinion. And 3 Chevy says, of course, that Jackson would do well to read this book, this little brown book with the round corners, called The Constitution of the United States. That's right. Yeah, most of those, I can't even imagine that most of those people that were up didn't even bother to like read it. But anyway, all right, so let's move on. So the next one that was up, which I think is just great, has to deal with the First Amendment. And what it dealt with was the petitioners in this particular case, which were representative of the pornography industry. They were suing Texas Attorney General Ken Paxton to try and stop the enforcement of what is Texas's House Bill 1181, that essentially was causing or requiring websites that handle porn to ask the question, are you of legal age? Meaning, are you 18 or above? And the Fifth Circuit held that the injunction itself, that an injunction over this was not warranted because the petitioners, meaning the pornography industry reps, were unlikely to succeed on their First Amendment claim. And so they essentially looked at that. The Fifth Circuit held that HB 1181 was a regulation of the distribution to minors of materials that are obscene for minors. So they went ahead and did that. The petitioners went and petitioned the Supreme Court to weigh in. And the Supreme Court basically said, yeah, HB 1181 triggers and survives what's called immediate or intermediate scrutiny, review under intermediate scrutiny, because it only incidentally burdens the protected speech of adults. Meaning that, yeah, requiring someone to provide their age is not blocking free speech. It's just basically sort of, if you think about this, it's sort of like having a requirement to get a concealed carry permit for a weapon. Now, granted, okay, you can make the argument about the Second Amendment that it shall not be infringed, which is the exact phrasing, but I use that as an example. So you can't sit here and say, hey, the Second Amendment can be framed in, certain requirements, like requiring you to go and take a class or something along those lines. You can't frame that in requirements for that. But what you can do is you can add a requirement that in this particular case, you need to prove your age, sort of like proving your age to buy alcohol. It's the same kind of thing. So, anyway, they went ahead and agreed with Texas. So, yeah, that case is going to basically be taken care of here in a little bit. But the other big one that was out there was the one that had to deal with, which is Mahmoud versus Taylor, which is the one that had to deal with the LGBTQ classes and storybooks being forced upon children in the Maryland, I think it's a Maryland school district. Let's see, where was it? I think it was Maryland, but I want to make sure. Yeah, the Maryland school district. Well, that one came down the way it should have anyway. Because there, the Supreme Court held that parents that are challenging the board's introduction of those inclusive storybooks, along with its decision to withhold the opt-out. See, now this is part of the problem. This case probably never would have hit the Supreme Court or never would have even been brought had it not been for the fact that the District of Maryland school board decided to basically say, yeah, you can't opt out of this due to religious exemptions. It never would have even gone to court had they just said, you know what? Yeah, we're going to, no different than health class. health class and that kind of thing. When you get to certain sections in health class, you know, you have the authority and the right as parents to opt your kids out. You should have that ability. And so that's why this case got brought. And by the way, it wasn't brought by just Christians. It was brought by Muslims as well. So anyway, they held that the parents are entitled to a preliminary injunction on the order of withholding the opt-outs. So the trial hasn't even happened yet. This is just a preliminary injunction to grant these religious exemptions, these opt-outs from the school district while the case is being tried. So this one fell exactly where it should have fallen as well. And so there you go. Those are my the three top ones out of the last 6 that were out there in terms of what was being available. Now I want to kind of go back to the birthright citizenship one, only from the standpoint, not of the opinion, but only from the standpoint of the birthright citizenship and the understanding of it. Again, I'm just pointing this out because of the fact that there is a clear historical record that demonstrates, and I got to switch my screens here, that demonstrates what the intent is of the 14th Amendment. So this excerpt that I'm showing on the screen is an excerpt of what's called the Congressional Globe. The Congressional Globe is a... Hang on, I got to let the dog out. The Congressional Globe is essentially the congressional record of the time, and it annotates and basically provides us with a transcribed record of what occurred. And in this particular case, this is the 39th Congress that was put together. Mr. Howard, which you see right here, Senator Howard of Michigan, is the sponsor, the Senate sponsor of what was known as, I think it's, give me just a second here. HR, House Resolution or Joint Resolution 127. Now, he states right here when they are presenting it for consideration and debate in terms of the wording of the amendment and how and what does it mean and how does it go, he basically states right here, he goes, the First Amendment is to Section 1. So he's amending the first section based on conversations that they have. And he says, declaring that, quote, all persons born in the United States and subject to the jurisdiction thereof are citizens of the United States and of the states wherein they reside. Now, he continues, because that's it, that's his phrasing, okay? He continues, I do not propose to say anything on that subject except that the question of citizenship has been so fully discussed in this body as to not need any further elucidation, in my opinion. This amendment, which I have offered, is simply declaratory of what I regard as the law of the land already, that every person born within the limits of the United States, and again, here's that word, and subject to their jurisdiction, is by virtue of natural law and national law a citizen of the United States. And these are the key words, subject to their jurisdiction, because you have to remember, historically speaking, this country was not the entire land. This country was bits and pieces and parts that were added to over the course of years. And in fact, we didn't even have everything until we ended up getting into places like over in California and buying that off of Mexico sometime later in our history. Now, this is the key. this is the key right here. He wrote that amendment, and he says in the very next paragraph, this will not, of course, include persons born in the United States who are foreigners, comma, aliens, comma, who belong to the families of ambassadors or foreign ministers accredited to the government of the United States, comma, but will include every other class of persons. It settles the great question of citizenship and removes all doubt as to what persons are or are not citizens of the United States. This has long been a great desiderium in jurisprudence and legislation of this country. He literally states right there, and it's right here in this. He literally states, whoops, wrong way. He literally states right here in the congressional record that it does not include foreigners, aliens, or persons who belong to the families of ambassadors or foreign ministers. So he is literally breaking out foreigners and aliens, meaning that you can't just come here, drop a baby, and that baby automatically becomes a citizen of the United States. Now, this does not include the idea, okay? This does not include the idea that a child born of at least one naturalized or natural-born citizen of the United States is not a citizen of the United States. So therefore, all of these lefties who are running around here saying, oh yeah, Melania and, Barron Trump, they need to get out of here if that's the case. No, you seem to miss the fact that Donald Trump is a U.S. citizen. That's all that matters. As long as one of your parents are U.S. citizens, either naturalized or natural born, meaning that they came from a naturalized or natural born parent, then you are a U.S. citizen. And that's essentially what the 14th Amendment was attempting to say. That's why they were saying, and subject to the, subject to the jurisdiction thereof. See, they were, back in the day, they were looking at it as you needed to have, not only did you need to be born here, but you also needed to have no allegiances to anyone else, which is what the Civil Rights Act of 1866 actually pointed out, which is where the 14th Amendment came from. They saw that and they said, you know what, this can get cut down the next time that we have a session. And they did not want the South, in particular, the Democrats of the South, to come back in and, raise the point and get rid of the Civil Rights Act, repeal, basically, the Civil Rights Act of 1866. So they said, okay, we're going to enshrine it in the Constitution. And that's what they did. The 13th, 14th, and 15th Amendments all came from this same time period. In fact, the congressional record discusses and has debates on all three of those amendments. So, if you want to change that definition, then the amendment, the Constitution needs to be amended to state as such. Also, too, can't forget this particular time period, not all Indians were actually considered. Indians, by Indians, I mean Native Americans. Not all Native Americans were actually considered to be U.S. citizens because they still had allegiances to their tribes. And so the general consensus was that if you had an allegiance to a tribe, you couldn't be a United States citizen. The naturalization oath that you take clearly states that you need to give up and renounce all connections and all ties to any other country before becoming a United States citizen. There is so many pieces of evidence that basically indicate that the Constitution, one, applies to U.S. citizens, and the fact that U.S. citizens had to have not only been born here, except for the very beginning, had to have been born here, but also have to demonstrate an allegiance to the United States. This is settled history. It's not in question. Anybody that questions this really needs to go back into the course of history and read all of this, because that's where it comes from. Well, anyway, and I'm sorry, I know there's at least one member of our group, of our Whiskey Warrior P1s, that disagrees with me, but I'm just demonstrating completely the history of the entire thing and the meaning of it behind it, the intent and the meaning and the debate and so on and so forth. There wasn't much debate in terms of the first line, by the way, that first setup, that once he made that amendment, there wasn't much debate on that particular amendment after that, because everybody understood what it meant. All right, so here's another thing that's going to be kind of interesting to go through. And I know Trump tried to do this before, and he's going to try and do it again. He wants to try and remove, whoops. And by the way, you can find that. It is for free. I downloaded the images. If you want, for that, you can find it as a part of the legislation website. But anyway, Trump is attempting to remove non-citizens from the census. Now remember, the census happens every 10 years. And the census basically applies to apportionment and everything else. There's one little problem, and that is that the apportionments clause in the Constitution does state that all persons must be counted. So I'm not exactly sure where he's going to go with this, because constitutionally speaking, if you're a person living here, legal or illegal, you need to be counted. Citizen or non-citizen, you need to be counted, because that affects the apportionment of federal funding, the apportionment of electoral college votes, the apportionment of seats in the House of Representatives, and so on and so forth. And this is part of the reason why the left is like freaking out about this attempt, and why the left is freaking out about all the illegal aliens being deported too. Because think about this. I saw this in the news. If they deport all of the illegal aliens that reside just in California alone, they would lose 2 electoral college votes as well as 3 seats in the House of Representatives. I'm not exactly sure how they can figure that, 2 electoral college votes versus the 3 seats, because the electoral college votes equals the number of seats in the House of Representatives plus 2 senators. So I don't know how that reporting actually came out that way, but the point is that it would change the electoral voting and the representation for some of these states that have been harboring all of these illegal aliens in terms of all of this. So anyway, Trump is attempting to remove them from the census. Now, the next census happens in 2030, and 2030 is when things are going to be taken care of. So we'll just have to kind of see what's going to happen with all of this. But I don't think that Trump really has a constitutional leg to stand on with this. So yeah. So anyway, I think that he'll have this. If he tries to do this, I think he's going to be taken care of. Now, granted, a lot of red state attorney generals and Republican legislatures are trying to clean up the census and make sure that illegals are not counted as well, according to White House Deputy Chief of Staff for Policy, Stephen Miller, said this last month. So, yeah. Yeah, we'll have to see, because, again, the Constitution states that all persons need to be counted. So, I don't know. It's going to be one of those things where it's going to be questionable at best. Well, I got to get you this takedown. This takedown is just fantastic, and then I'll leave you at that. But this takedown is just fantastic in the Daily Fetch. This guy, Brandon Gill, He's speaking. He's U.S. representative from Texas, and there is this guy, Dr. Sean Harper, who is a quote unquote scholar who specializes in DEI policies. He was testifying before the House Oversight Committee hearing. And, well, let's just say that Representative Brandon Gill kind of caught him in something. And, yeah, you guys should definitely listen to this.
Which race do you think should be preferred?
I do not think that a single race should be preferred.
You just said that you believe that race should be considered in employer hiring practices.
I don't know. There's going to be a transcript of this hearing. I didn't say that in that way.
Okay, why don't you explain what you believe?
What I
Very
said
briefly.
and what I believe is that the demographic composition of workplaces,
Which
our
is,
nation's military,
by
and
demographic
so on,
composition,
our Congress ought to reflect the diversity of the United
racial
States of
demographic
America.
composition. Racial demographic, is that what you're saying?
Racial, gender.
Okay, so race should be a factor in employer hiring practices. Yeah, that's what you're saying, is it not?
Organizations ought to attempt to match the diversity of their...
hopping around the question.
No,
you don't want to
I am
answer
answering
it.
quite straightforwardly,
Who
as a
gets
matter
to
of fact.
determine which races are preferred?
I already told you I don't have a single racial group.
You just told me that you believe that the racial demographic makeup should be taken into account in hiring practices.
And it should be reflected in all levels of companies and other organizations.
Oh, folks, this is why the leftists have some serious problems with their ideologies. So, first of all, I mean, asking the question, number one, which race is going to be more preference or more preferred, which is exactly what DEI actually does, okay? What race needs to be preferred? He says, no, it should reflect the diversity of America. Oh, okay. So then how about this? How about we break down every single business, every single public office, every single government entity, every single school, why don't we just go like this? So that means that based on the racial makeup of the United States, where 13%, roughly, maybe 15%, let's just give it 15% for ease. 15% of the country is made up of black folks. And so what you're saying then is that 15% of every single company, government entity, so on and so forth, needs to only hire 15% black folks. Well, I hate to tell you this, buddy, but that doesn't go across everywhere, because I guarantee you there is a higher percentage of black Americans in places such as Georgia, Alabama, and even some of the Carolinas and stuff. There's no way that could work. You also can't force companies in, say, Wyoming or Idaho or Washington, where the disparaging proportions on it, you literally have zero methodology to be able to enforce any kind of race-based logic in hiring systems across the board. You cannot do it. You cannot do it. And so the only logical answer is to throw out the idea of race-based hiring itself. Period. Meaning that what you do is you go to what the Americans, the true Americans who are out there, say, which is essentially you hire the best person for the job, regardless of what their hair color, skin color, so on and so forth has to go. Okay? And you just basically throw this all out, throw this crap out completely. And if you're qualified for the job and you beat out all the other applicants based on those characteristics and qualifications, then you're done. There's no question in terms of race, sex, sexual orientation, creed, religion, whatever. Doesn't matter. None of that should matter at all in terms of any kind of hiring or practice in terms of the workplace, period. So this guy got caught because he basically was asked, hey, which race is more important than the others? You know, persons of color. Yeah. No. There is no way for us to break that down. None. There is no way for us to break that down and get that taken care of. You just can't do it. So the best recourse and the best solution is to just ignore race and go back to the point of the meritocracy system. All right, folks, that is it for me for this evening. Do me a favor, if you haven't already, head on over to rumble.com, get yourself an account. It is free. And once you are signed up and signed in, make sure you hit that, make sure you search up the American Perspective channel and hit that green follow button to get notified every time I go live. Also, too, don't forget to give me a thumbs up or a thumbs down if you really want. And on all of my platforms, whether it's X, YouTube, Facebook, and, of course, the aforementioned Rumble. We will see you tomorrow night. Tomorrow night is 1 hour later because it's Saturday. So tomorrow night at 6 p.m. Pacific, 9 p.m. Eastern Time, right here on American Perspective, I've got one last thing to say. Landon, who's a good boy? Have a good night, Landon. Yeah, I haven't done that in a while. Anyway, we'll see you tomorrow night. Have a great rest of your evening, and good night.